Further hearing in the appeal, Webb against Webb.
Mr. Hikaka, good morning. Apologies for keeping everybody waiting for a few minutes.
I thought before I began where I left off, I would inquire if there's anything that has occurred overnight that you would like me to address now before continuing on.
Thank you. Yes, Mr. Hikaka, and obviously I'd like to hear from both sides on this, but in 1915, at any rate, a trustee in bankruptcy in New Zealand would have recourse to property in the Cook Islands for the purpose of getting in the bankrupt estate. Now, I appreciate that's a long time ago, and that was before the Cook Islands became independent. We haven't been able to find anything subsequent about the reach of the New Zealand trustee in bankruptcy and whether it extends across to the Cook Islands. We would very much welcome any help you can give us on that question.
So, my Lord, that provision in the Cook Islands Act 1915 remains as it was 1915, unamended. Whether the New Zealand official assignee in bankruptcy of a New Zealand could actually overcome the foreign revenue rule in that context, I'm not sure. We would say the revenue rule would still apply. But part of the difficulty with the interaction between the Cook Islands Act 1915 and indeed the Matrimonial Property Act, where it refers to the official assignee, and bankruptcy, is that there is no bankruptcy in the Cook Islands. So, yes.
Sorry.
One cannot be bankrupted in the Cook Islands.
So if somebody is insolvent in the Cook Islands, somebody has to go across to Auckland to bankrupt him, do they?
Potentially, my Lord. I'm not sure how it would actually work. And this is a source of difficulty. The importation of New Zealand statutes into the Cook Islands is often not done with a proper consideration, with respect to the Parliament of the Cook Islands, with a proper consideration of how those provisions might actually transfer. So my learned instructing solicitors advised me of a situation where under the Companies Act 1955, I believe the liquidator of last resort, if it will, is the official assignee. But there is no official assignee in the Cook Islands, so one cannot actually appoint that person, or because the office doesn't exist. So,
but that wouldn't, I mean, if the 1915 bankruptcy code remains in effect, presumably one could get a trustee in bankruptcy appointed and not have to have recourse to the official assignee.
Sorry, my Lord, I think I might have lost you at the end of that.
Yes, I was suggesting that the fact that there isn't a separate official assignee in the Cook Islands might not stop an effective personal bankruptcy taking place in the Cook Islands by the appointment of a private person as a trustee instead of the official assignee. I mean, presumably you have trustees in bankruptcy in New Zealand, and the official assignee is the trustee of last resort.
Shall I say this? Trustee in bankruptcy equivalent? No, my Lord.
Okay.
The official assignee is the only trustee in bankruptcy in New Zealand.
So we have a Bankruptcy Act, which is self-contained.
Yes, because New Zealand, under the Bankruptcy Act, is a self-contained bankruptcy system.
Yes.
And that's where the official assignee is, and there's no equivalent system in the Cook Islands.
No, I'm talking about New Zealand at the moment.
Oh.
If the New Zealand bankruptcy code, presumably not every bankruptcy has to be done by the official assignee.
I think everyone does.
Yes, as far as we're aware, my Lord.
Well, it does.
Everyone does. Yeah. Yes. He has a fair bit of work to do.
That certainly looks as if it fits in with, say, Section 28 of the 1976 Act, which is talking about who can make an application, and it just says the official assignee in bankruptcy. It doesn't say anybody else who is acting in that respect.
Yes, my lady. And a good illustration of the poor fit, when the Act was picked up and placed into the Cook Islands, the provisions regarding the sanctity of title to native land was protected, and the need to have New Zealand references read as Cook Islands was protected. But these mechanical provisions were just picked up and dropped in, and they just don't operate. They don't.
Practical matter, how will it work in the case of Mr. Webb if bankrupt him in New Zealand, and what measures could then be taken in New Zealand by way of enforcement of that bankruptcy or trying to recover assets in the Cook Islands?
A good question, my lord, and one that, from the case law, seems untested. If Mr. Webb is bankrupted in New Zealand, then the official assignee will first look to all of his New Zealand assets, and they will no doubt attempt to take a broad view of that, and that is why they will have placed, why there will be arguments about the charging order placed against what's referred to as the Arnie Road property, as to whether that Yogi Trust are actually assets available to Mr. Webb.
On the assumption that the New Zealand Code of 1915 is broadly speaking based on something like the English Code, which is without knowing what it actually says, the ordinary principle is that when somebody goes bankrupt, his relevant property vests in the trustee. The trustee doesn't pick and choose which property does or doesn't vest. It just vests. Now, if that's the position in the 1915 Bankruptcy Code, and it extends to property in the Cook Islands, and that's never been repealed, why doesn't the property in dispute in this case, or wouldn't, it vest in the official assignee in Auckland if Mr. Webb is made bankrupt in Auckland by the revenue? After all, the revenue can presumably make somebody bankrupt.
Oh, of course they can, and the official assignee would then take his bankruptcy in New Zealand. The difficulty, my lord, is submit that the official assignee in New Zealand is not the official assignee in the Cook Islands. Post-independence of the Cook Islands, there must have been some difference, and that's why the Cook Islands courts, in respect of the Company Act issues, even don't appoint the New Zealand official assignee as the liquidator of last resort over Cook Islands companies, because they say that role does not exist in the Cook Islands. So I respectfully submit, if the role doesn't exist in the Cook Islands for liquidator of last resort and Company Act purposes, it also can't exist. That same role can't exist in respect of bankruptcy purposes. There is simply no official assignee in the Cook Islands. And we submit that one cannot pick up the New Zealand official assignee and have him or her extend reach extraterritorially to the Cook Islands and other sovereign states.
Did the 1915 regime apply in the Cook Islands as a matter of Cook Islands law? Because a trustee who apparently is given by the 1915 Code the right to have recourse to Cook Islands property situation in the Cook Islands, could only exercise that right if that was the law of the Cook Islands. My question, therefore, was the 1915 Code either part of the law of the Cook Islands or reflected by a similar provision in the law of the Cook Islands in 1915?
Yes, it was, the Cook Islands Act 1915.
So there was a similar Cook Islands Act?
The same Cook Islands Act, my lord.
One unit, then?
Yes, so the Cook Islands Act 1915 of New Zealand was passed by the New Zealand Parliament and then continued in force as one of the acts that continued in force upon independence.
Yes. So there would have to be a repeal of it before it stopped being effective on Cook Islands property, wouldn't there?
We submit not of the substratum of the Act, i.e. the office was abolished and therefore no bankruptcy in the Cook Islands. Otherwise, contrary to the position, as I understand, taken in the Cook Islands courts, there would be bankruptcy available in the Cook Islands, and it would just be through this mechanism of the Cook Islands Act. But there is no personal bankruptcy in the Cook Islands.
I always thought the Cook Islands was a wonderful place, but I had no idea that you couldn't be made bankrupt there.
And of course there are positives and negatives to that, my lord, because then you're saddled with your debt until you can repay it, which is why most places do have a bankruptcy, but not the Cook Islands.
So there's no personal bankruptcy in the Cook Islands?
Yes, I'm going to confirm that with my
But just help me. Are you saying that came about simply because there was an office of official, what's his name?
the official assignee.
Official assignee, and it was abolished?
May I just inquire with my solicitors on this?
Yes, certainly.
Thank you.
It must be personal.
Yes, that's the...
To give what assistance we can, my lord.
Perfectly all right.
There has never been an office of the official assignee in the Cook Islands. The New Zealand unitary bankruptcy model, unitary because it all must go through the official assignee, was first created in 1967. So it appears that originally under the original code, one would have been bankrupted, and the official assignee in respect of New Zealand could have enforced against Cook Islands assets, all part of the same realm.
Yeah.
But with the separation of the Cook Islands into an independent state in 1965, we submit that would have required then the Cook Islands, if it wished to continue that, to actually have its own bankruptcy regime, or at least appoint an office of the official assignee. That has not happened. Hence the situation we are in today, where there is no personal bankruptcy in the Cook Islands.
Bill, did you want to ask?
Yes, I wanted to ask about the practicalities. I'm thinking about what we've been told by Mr. McNally about the Revenue Department having brought proceedings in New Zealand for the appointment of a receiver and seeking to enforce that in relation to the assets in New Zealand, but also in the Cook Islands. Now, we've been looking at the debt and the extraterritoriality of the debt. What assets in the Cook Islands? I mean, I know this is not your case, but what assets would be available in the Cook Islands?
Official assignee
Yes.
in right of New Zealand. Well, our primary...
Forget about anything which is quite clearly chattels and so on.
Well, we would say none, because the official assignee in right of New Zealand would be seeking to enforce a foreign tax.
Well, leaving that to one side, I'm talking about what actual assets, because the matrimonial home is part of the trust assets. Where was the trust set up?
The Cook Islands.
The Cook Islands.
And it's, I forget the clause, but it is expressed to be a trust under Cook Islands law.
So then the official, official assignee in bankruptcy from New Zealand has to get round the Cook Islands Trust in order to get those assets?
Yes.
Because there's nothing else?
No, well, there's Mr. Webb's Rolex watch, I believe.
Yes,
that's
okay.
it.
But
I couldn't hear that.
the
Sorry,
Rolex watch.
The Rolex watch, I believe that's it.
So we can forget that. So he's got to get round the trust to get to the assets.
Yes, my lady.
Right.
Of course, at the moment, Mrs. Webb also needs to get
Of
around
course.
the trust to get her.
Yes.
You're all creditors, yes.
But I'm sorry, and we were told that there's some proceedings which to appoint a receiver of the Cook Island property. I mean, you don't have any knowledge of that. And from what you're saying, I mean, I don't quite see how the revenue could be mounting such proceedings in the wake of the Court of Appeal's judgment in this case, which says they're not enforceable.
Yes, my lord. So I don't know. That was the first I had heard. I was aware that the Revenue Department was certainly seeking to enforce, to bankrupt Mr. Webb
Yes.
in New Zealand. I have to say I don't know how they are seeking to appoint a receiver in New Zealand over Cook Island's assets.
I mean, faced with the judgment of the Court of Appeal in this case, they would have a lot of problems.
They would.
And indeed, presumably this case has been quite well publicised in the Court of Appeal. I mean, one would assume the Revenue were aware of it.
I understand the Revenue are aware of this case.
They haven't sought to intervene in any way in this.
No, and that would be an unusual intervention, of course, because it would be the tax department of a foreign state seeking to intervene.
Yeah,
in
it would indeed, but it leaves us in a very difficult position because we simply don't know what's going on.
No, we don't know what's going on, and I'm sure my learned friend's advice to the board reflects his instructions as to what's happening, but if the instructions are coming from Mr. Webb, set aside findings on on the veracity of his evidence, he is a layperson. He might not understand the full actual technicalities of what's involved here. I'm not sure I do.
I just have one further puzzling question. When somebody is made bankrupt, the powers of the trustee and the provisions for vesting in the trustee or the official are for all the creditors, not just the particular creditor who may have presented the bankruptcy petition. So what happens where the petitioning creditor, let's say, is the Revenue, but there are lots of other debts? Is there a sort of dual pool, one pool for all the other creditors, which will extend to the Cook Islands, and some totally separate pool just for the Revenue? I mean, that as a concept is quite difficult to get one's mind round.
Your Lordship is asking with respect to New Zealand?
Yes.
Yes.
In New Zealand bankruptcy law, what happens if the Revenue is the petitioner and some offshore piece of property that otherwise is accessible by the trustee, does it suddenly become inaccessible just because the petitioning creditor, who may be one of many creditors, is the Revenue?
Not certain of that, my lord. But there is a step-down mechanism in terms of priorities in bankruptcy, and I forget the full order of priorities, but it's basically whoever put the person in gets their costs out first, then the official assignee's costs, then the Revenue has a priority claim in respect of certain aspects, at least, paid wages being one, and it steps down like that. But
I think we call that a waterfall.
Yes, exactly. Your Lordship's question about a foreign asset and whether the official assignee in bankruptcy can then go and get that internationally, I'm not sure the answer of. The basic principle in Government of India and Taylor would indicate that no, they cannot. But of course, the other creditors might, and the fact that everyone's dealt with under this by the official assignee standing in the shoes of all these creditors, that would probably present quite a complicated issue for the courts of whichever jurisdiction that was being enforced in.
Okay.
On a quite different note, there are many jurisdictions dealing with financial provision following divorce. I'm thinking of England and Wales, obviously, where maintenance and property are looked at globally. Here there is a complete division. and we are told, oh, well, there's maintenance going on, but we're not told anything about it, because this is simply the 1976 Act. You work your way through it, and you get to a result. But in terms of getting a better picture of this husband and where his businesses are, and what his income is, out of which your client has been awarded some maintenance or other, we have no clue. And it might be relevant to our consideration of his New Zealand links and the extent to which he is actually going to be required in one way or another to make a significant contribution to this judgment debt, to know a bit more about his income. You must know something about his income because you've got a maintenance order. But, I mean, is his income being generated in New Zealand from these various enterprises of which we have heard something in the old days?
If I may approach that in two stages, my lord. The
Two.
first is the maintenance decision, from memory, is included in the judgment of the High Court, Her Honour Justice Potter, which maintenance is addressed page 318 of the electronic bundle, page 307 of the physical record, volume 2.
318. So you've added 11 to that, have you? So I go back to
Yours
307.
is 307, my lord, sorry.
That's okay. Yes.
So that is where Her Honour Justice Potter.
So what are the findings about the husband's income, size and source?
There are no findings as to source.
$105. Mr. Webb says he has a limited income of $2,000 to $3,000 a month. Says he has. Any findings about the size of his income?
There was a separate judgment on maintenance by Her Honour that I don't have and can't recall the details of. What happened was Mrs. Webb has received a maintenance payment. I can't remember the exact amount. But then what happened was that was varied after the Court of Appeals judgment because Mrs. Webb is receiving rents from the other properties on the land, so it was reduced by the amount of that property. So that's the information that is there regarding the maintenance. I'll just check. I'm certain because my instructing solicitor has had to do a fair amount of chasing of maintenance payments.
Yes.
So he probably will actually have the figure to mind.
Thank you.
The new maintenance figure, there's $1,500 per month for Bethany, that's by way of child support. Then $1,800 per month for Mrs. Webb, except during term time when she is teaching, when it is reduced to $780 per month.
And no findings by the courts as to the amount of the husband's income or the source of it.
Sorry, if I may just look through this judgment
Thank you.
to see whether there's an actual finding on that. So with regard to the paragraph on Mr. Webb's earning capacity and financial resources as the title, Her Honour repeats the paragraph in the judgment we've just looked at, where he said that, and then says as follows. Mr. Webb's affidavit of 13 February 2018 provides no further information as to his earning capacity and financial resources. He notes he pays child support and costs for his son Sebastian, but no details are provided. The ground stated in 4C of his application dated 19 January 2018 that his ability to pay maintenance has substantially diminished is not supported by any evidence. The essence of Mr. Webb's claim that the support orders for Mrs. Webb and Bethany should be discharged or varied appears to be not his inability to meet the payments ordered, but Mrs. Webb's increased ability because of the income she now receives from the property. To summarise the position, I think, my Lord, is unsurprisingly, I submit, given the evidence on the matrimonial property proceeding, Mr. Webb hasn't told us what his income and his sources are. So we're all in the dark here with somebody who is not prepared to fully and properly disclose his position to any of the courts that he has been before.
Were this appeal to be allowed, you would be aspiring to increase the maintenance, wouldn't you?
So, my Lord, no, because if this appeal is allowed, yes, allowed. I thought I was on the other side. Yes, we would do that to try and at least bring it back to the position it was before property. Because,
well, I mean, presumably your client would need to pay some rent.
Yes, well, yes, and she hasn't needed to pay any of that, and she would lose all the income from the rent that she currently receives.
Well, quite.
As owner
She'd
of the leasehold.
need to provide herself and her daughter with a home.
Yes, my Lord.
Thank you very much. Now, where were we, Mr. Mikaka?
We had just gone through the provisions of the deed. So we had gone through the terms of the deed, and what I propose to do now is actually put in different words, more succinctly, what those terms actually mean. So I will just orient ourselves with the deed, as I say. I'm using the copy at page 824, physically 835 electronically, the easier to read copy. What does Mr. Webb, when he wrote this document to himself, say? He says, I hold some of my property, that's the preamble, for myself and Sebastian, that's clause 2, or whomever else I choose to hold my property for. That's found because of clauses 2 and 10.1. It says, I hold this to give the whole or any part of that property to any one or more of those persons as I in my uncontrolled discretion wish, including giving the property to myself, without needing to preserve the property. That's a combination of Schedule 1.1, the general law, and Clause 14.1c. It says, in deciding what power or discretion I have to deal with my property, I shall be given a reading that gives me the broadest, most liberal and least restrictive use of my powers. It's clauses 3.1a and 13.1a. Then says, I shall hold the property in this way for 21 years, that's clause 9.1, unless I have earlier given away the property, schedule 1.1, at which time, the end of 21 years, I will give the property to whomever I decide, the combination of schedule 2.1 and clause 10.1 and clause 2. Then says, at any time, I may vary any or all of the terms upon which I hold the property. And finally, he says, no person for whom I hold the property or any third party has any claim, right or entitlement to call for accounts in relation to the property, obtain any information of any nature from me in relation to the property, or in relation to how I hold the property or the powers. That's my summary, my lords and my lady, of what that deed says. What does that mean then as a matter of law? And this is where I'll address the Clayton style argument, I think. It's a deed that gives Mr. Webb the power to distribute the property to whom he sees fit, including himself, in such proportions as he sees fit, on terms he can vary as he sees fit, and no one has any right or claim to information about the property or how he is using it. So, given that, can Mr. Webb recover the property to himself? And we submit yes. So let's consider, if we may, what's been created under this deed, if anything at all has actually been created. At best, Mr. Webb has created a general power, we say. Now, we're in a slightly unusual position here because my reading of the cases, and certainly the texts, actually proceed from the basis that the general power is given by person A to person B. I give my art collection to my learned friend, Mr. McAnally, to hold and for him to distribute as he sees fit. Classic general power. Here, the situation is I give my art collection to myself to distribute as I see fit. I'm not sure that actually has created anything, because that's what I can do with my art collection anyway. It's an instance of it being my art collection. So that's why we might not actually have anything created by this deed.
That's the Ararangi Trust.
Yes, my lord.
You're going to come to the Webb Trust in due course, presumably.
I will, and if it's acceptable, I would propose to do that at the end after having gone all the way through the other. What is most commonly seen in certainly New Zealand is what's known there as a discretionary family trust, which is actually a combination of two separate parts. One is a power of appointment that can be exercised in favour of a large number of objects, who are usually termed the discretionary beneficiaries. So, during the life, I hold the trustees hold for the personal advancement of my children, my grandchildren, quite usually a very large class, including charitable institutions. That is usually coupled with an obligation to distribute the property on vesting to a more narrow and defined class, for example, my children, and they're termed the final beneficiaries. And the reason I'm setting out this, my lords and my lady, is because it helps understand the Clayton case and the, to a lesser extent, I'll touch on the Financial Markets Authority and Hodgson case, because those are two New Zealand discretionary family trust cases that have some of the provisions or the effect of the provisions in the judgments. So that's your usual situation, and under that usual situation, as objects of the power, the discretionary beneficiaries have only a hope that the power will be exercised in their favour, a mere spes. Because it's based on a mere power. The final beneficiaries, in contrast, have something more. They have what, I'm using, I think, the Underhill term, a proprietary beneficial interest in the trust property. However, that interest is whilst a final proprietary property interest in trust is valueless, because at any time prior to the vesting date, the property may be distributed to others before vesting. Now, it's only at vesting that their rights would crystallise. That contrasts, that distinction between where there being a mere power over a broad class and a more defined power that gives a property interested equity to the final beneficiaries, contrasts to the Aotearangi trust deed, and indeed the Webb family trust deed, because under that deed there are only at best objects of mere powers, because Mr. Webb has the power to remove and replace any beneficiary at any time under clause 10.1. Because of that, there's never somebody who has a claim to the final beneficial interest upon vesting date. They could always be removed by or replaced by Mr. Webb. We say that what that actually means is the beneficial interest here, any beneficial interest here, is ambulatory. It's more in the nature of a will, death, because it can change at any time, and that power can be removed, and that interest can be removed. The best that anyone would have under this deed, if they have anything, is two hopes. One is a hope that they will receive a distribution, i.e. be the subject of the exercise of the dispositive power, and the second is a hope that they will not be removed as a beneficiary. That's all they have here. Over under that, Mr. Webb is quite able to appoint the property to himself. There's no one that has a proprietary beneficial interest that would be defeated by such an appointment. He is the trustee, and thus in control of who gets the property, and he is a beneficiary. In some ways, to adopt the words of Justice Opjohn as he was then in Re Triffitt's settlement, this is a power conferred by Mr. Webb upon himself for his own benefit over his own property. The appellant has suggested that there would be, in the written case at least, an anathema for the trustee to act in his interests and against those of the beneficiaries, but we say, having regard to the terms of the trust deed, that's not correct. He can appoint property to himself. Now, first, it is a well-known principle of law that a dispositive power can be exercised by a trustee in his or her own favour without breaching the self-dealing rule, where either A, the rule is disapplied by the terms of the settlement, or B, the trustee is placed in a position of necessary conflict by being given a power which is expressed to be capable of being exercised in his or her own favour. And in case that sounds familiar, I take that formulation from my Lord Briggs's decision in Breakspear and Appellant. It's a classic statement of the power there. Here, the deed gives to Mr. Webb as trustee the power to appoint to himself as beneficiary.
You seem to be saying the same thing with respect. Many times you make the basic point, and he can give it to himself and change the deed to get rid of anyone else. And the deed requires it to be interpreted to give him as wide powers as possible. And that's okay.
Well, in which case, my Lord, maybe I don't need to make the point again, and I'll compare it, because it is actually a relatively simple point.
Yes, that's what I thought until you started. You seem to make it a lot more complicated.
I mean, in a sentence, what do you say in response to Mr. McAnally, who said, don't forget these powers are fiduciary? What do you say about that?
Well, first I say, what are the actual fiduciary duties that attach to those powers? It can't be the fiduciary duty to against self-dealing. It can't be the no conflict and no profit rule. At its very best, first we'll say, given that anyone can be removed, and we say that power of removal of beneficiaries can't be fiduciary, because it's reserved to Mr. Webb from his own property, and it must always be exercised against the interest of whoever is removed, so it can't be fiduciary. At best, the only fiduciary power here would be a fiduciary obligation, duty, would be a duty to consider the interests of the other discretionary beneficiaries, in this case Sebastian. Now, as I say, whether that's real, given that Sebastian could be removed.
It's perfectly common to find a fully discretionary trust in which effectively, quo ad any particular beneficiary, that is the limit of the trustee's obligation. Doesn't stop it being fiduciary, because he has an obligation to consider the needs and requirements of the whole potential class, as I understand it. But your point here is it's clause 10. And anyway, he's named as a beneficiary from day one. Yes.
Yes, my lord.
Yeah.
And to add something of a gloss, even if we have regard to that power, this is where some aspect of, as the Court of Appeal of England and Wales put it in the Charman case that has been adopted by a number of jurisdictions, there must be some need for worldly realism here. Here, the people who could complain about any exercise of the powers are, at best, Mr. Webb's 2 minor children. Also, what complaint can they have? They have a complaint that says to Mr. Webb, they can ask, well, assuming they can get through clause 19.1, they can ask Mr. Webb, did you consider me when you decided to exercise your power? Mr. Webb can say, yes. To challenge that as being a breach of fiduciary power, they would need to prove either irrationality or dishonesty on the part of Mr. Webb, a very high threshold.
I think Lord Conworth is right. I think you can take all this pretty shortly.
Thank you.
Do we need actually to look at the Clayton case? Obviously, we have in our own time looked at it, and we see the 2 ways of the analysis, invalidity or bundle of powers. You rather commend bundle of powers. Maybe that would, whatever our conclusion on this, that would be the line that we would take in analysing this issue. Do we need to look at Clayton?
Probably not, my lord. The point I was only going to look at Clayton for was to show that the powers in this deed are much broader than even the powers in Clayton. And I might just quickly note why for the board's reference. That, of course, in that case, Mr. Clayton couldn't alter final beneficiaries. Here, Mr. Webb can. The power to vary the deed in Clayton was not as broad as in this case. That was only a power of amendment to amend management and administration. And the interpretive provisions of the Vaughan Road Property Trust deed were not as broad as the interpretative provisions to be applied in respect of the Ararangi Trust deed. For the sake of completeness and candour, I do note that there was an express clause permitting self-dealing in the Clayton deed that's not present here, but we submit, given the effect of the common law, that is actually of no moment, because as a matter of law, I distribute to oneself.
If you say successfully that this is not a trust in fact, that destroys the bundle of powers argument, doesn't it? Because they derive from the trust. But you get to the same end result because he can do what he wants with it either way.
Yes, my lady. Either...
So it's language, really.
Yes. Either there's no trust, so it's actually held by him anyway, or there's a bundle of powers that are such that it is in effect held by him anyway.
Your valuation of the bundle of rights depends upon the clause 10 power being assignable, doesn't it? Or is it a valuation in the sense of value to him rather than value to anybody he might try and sell it to?
I think value to him, my lord.
So you say you don't have to assert that the clause 10 right is assignable?
Yes, my lord.
What would happen on his death? Would it pass to his estate?
It would do, yes, if it's held to be... if it is a power, then yes, it would pass. Yeah. And we draw support from that from the In re Triffitt's case. We draw support for that from the In re Triffitt's case, where in that situation the power was held to be assignable notwithstanding the fact that it required the consent of some trustees to do that.
Now, you refer to the financial markets case. Do we need to go there?
No, I don't think so. That's another case that has discretionary things. That one failed because there was an express no self-benefit clause in it.
So now, briefly, the Webb one. Different set law.
Yes. And that does pose an issue with the 10.1 argument. I accept that because that power is held by someone other than Mr. Webb.
Just remind me who the settlor is.
A Mr. Ellison, who managed to spell his own name incorrectly on one page of the document, of course. But
Where do we find that?
it is at page 605 physically, so 616 electronically. It is in Record Volume 3. Sorry, it actually starts. Yes, no. I got
Sorry, what's the paper page number? Because I'm afraid at this stage in the pagination, it's not an 11-page difference.
Oh.
Some other index creeps in that increases it up to 11. So what's your paper page number?
Paper page number is 605.
Thank you. Yeah. So that's 613 on for some reason.
Who's Mr. Ellison?
He appears to be, the evidence is that he is a business colleague of Mr. Webb's. He is mentioned in the, I believe it's either Chief Justice Weston or Chief Justice Williams. The Chief Justice has changed during the course of this case. As somebody who filed an affidavit saying, I have leased the Arorangi property from the Arorangi Trust, and I need Mrs. Webb to move out so I can continue to, so I can rebuild it and lease it out to someone else. That was rejected as improbable and likely a sham by the judge who saw that. A notice of requiring Mr. Ellison for cross-examination was given before hearing, and what happened was, rather than Mr. Ellison turning up for cross-examination, his affidavit was withdrawn and Mr. Webb said he wouldn't rely on Mr. Ellison's evidence. So that is Mr. Ellison, my lady.
So you say the court's entitled to infer that really the real settlor is Mr.
And now, certainly even the de facto settlor of the majority of the property that claims that is said to have been settled on was Mr. Webb. The only thing we can see is Mr. Ellison's $10, which might have gone in.
Because anybody can add property to the trust.
Yes, ma'am.
There's been a concession that this should be treated by the court in the same way.
Yes, ma'am.
Was that a concession made below?
That's recorded in the Court of Appeal's decision, my lord, and forms the basis of why they didn't consider the two deeds separately. So, for completeness, I'm happy to go through why, even though it is a more winding path, we get to the same result in this deed.
No, there was no concession in the High Court.
No, my lord.
I think in the light of the concession, I don't think we need to trouble you on that further
Certainly.
dimension.
In the interest of full candour, because my learned friend indicated he might address this, I personally cannot remember the concession being made, but both Mr. Marshall and Ms. Clues can.
Right.
And that probably speaks more to my faulty memory, and they identify.
Thank you, Mr. Ikaka.
So, having regard to that, do you wish me to address these parts of the...
We don't wish you to.
Unless it's withdrawn. It's been withdrawn.
I do have difficulties with aspect of the Court of Appeal judgment and the submission that a concession was made regarding clause 10.1. Specifically, I certainly don't recall any such concession being made. And distinction was in fact overlooked, at least by the court and possibly by the parties in the course of argument. So I was going to raise the matter when my time came to reply, but I was not going to invite the substance of the point, then we may have a bit of an issue there.
Did you raise in your case that you disagreed with the Court of Appeal's recording of a concession?
I did not read the Court of Appeal judgment as recording that a concession had been made. The paragraph that I was referring to, paragraph 53, refers to the common ground that the trusts stood or fell together, but not only do I not record the context in which that may have come up in the course of argument, there's no suggestion in my submission in the judgment that a concession was specifically given in relation to clause 21, and I would regard it as somewhat remarkable that anyone would make a concession when quite clearly the two settlers are named as two different people. What that paragraph in the judgment may refer to is an argument around the invalidity of the trust generally, because the board will see from the Court of Appeal judgment clause 10.1 was not predominantly relied upon in terms of that invalidity, but that is the distinction. So other than clause 10.1, the trusts would stand or fall together, but I certainly don't accept that a specific concession was made on such an important and obvious matter, and if it had been, it would have been recorded in section 63 of the judgment, where the Court of Appeal does deal with clause 10.1, doesn't, and appears to simply overlook that there are two different settlers.
Thank you, Mr. McNally.
Thank you, my Lord.
In paragraph 52 of its judgment, the Court of Appeal said it is common ground that the two trusts stand or fall together. In my view, Mr. McAnally should, in his case, have questioned whether the Court of Appeal was right to regard that as common ground. At all events, he gets to his feet now and says that it was not common ground. In those circumstances, albeit very briefly, please make your arguments why you say the difference of set law in the Webb family trust should have no impact upon the resolution of this issue in the appeal.
Certainly, my Lord. While Mr. Webb couldn't replace beneficiaries, he could still distribute the property to himself, he could still resettle the trust property, he could still amend the deed, and he could still replace his co-trustee.
Sorry, could you just may have this again a little bit slow?
He could still distribute the property to himself, resettle the trust property, amend the trust deed, and replace his co-trustee.
Or simply ask his business colleague to exercise the Clause 10 power in a particular way.
Yes, my Lord, or that. Now, there is a second trustee, Ms. Dixon, and the first three of those powers, not the replacement or the request for 10.1, would need her to be involved or her approval. We say she is not a truly independent person or an independent person at all.
She's his new partner.
Yes, my Lord. This is where worldly realism does have quite a bit of purchase. I refer to my earlier points about what would actually be required to challenge any exercise of the two trustees here. Overall, on the trusts and to... So that is my argument on...
Thank you.
To just summarise, I think the end position on these trusts, if these trusts are allowed to stand as trusts, we submit that that ancient and venerable institution is hollowed out. I'm reminded of Lord Denning's language in Morgan and the Inland Revenue Commissioner, a case referred to in the TMSF decision at page 1105 electronically, 1094 physically, where he talks about a magician, a magic act having occurred to disappear an interest. Here that magic act is Mr. Webb, and he invokes the term trust to create a cloak that does not limit his enjoyment of the cloaked assets, but apparently protects it from everyone else, including his wife. And we submit that that cannot stand.
I think we needn't go into the rule against perpetuities.
Thank you, my Lord. I also then apprehend we probably don't need to go into section 44 either, because that's really about, it's primarily aimed at Arorangi Trust to Webb Family Trust dispositions.
If we felt that we needed to go into that, we've got the written arguments, and I don't think they would be improved even by you, Mr. Garg. Already.
That leaves only the also, I don't think I need to address sham, unless that would be of much assistance.
I don't think you do.
Only that last question on valuations.
Quite.
And I respectfully submit that this can actually be dealt with relatively easily, without the need to pore through and try and find what little evidence there is, all of which is set out in the written case. Because the starting point we submit is the obligations of disclosure in matrimonial property cases. And I no doubt do not need to read out, probably don't even need to remind the board of the comments of the Supreme Court of the United Kingdom in Prest and Petradell about the importance of disclosure and the inferences, and the similar comments from the Court of Appeal of New Zealand in Clayton and Clayton. Both are to the same effect, and quite properly so.
Paragraph numbers in Clayton, where the court...
Sorry, it's in my case.
Carry on in the meantime, if...
Thank you, my Lord. Now, the concerns about Mr. Webb's disclosure were raised early and often in this case. Oh, yes, it is, sorry. Oh, is it here? Right, it's paragraph 106 of the Clayton Authority, and the citation, the neutral citation for Clayton and Clayton, my Lord, in the Court of Appeal is 2015 NZCA 30. An order for discovery was made on 14 June 2016. A further order was sought due to non-compliance on 15 July 2016. A further discovery order was made by His Honour Justice Williams on 1 August 2016. Further concerns about the discovery were noted by Chief Justice Weston in September 2016, and full discovery, and you've got the discovery sought, was further sought by Mrs. Webb on 13 March 2017. You say the respondent did all she could to try and get documents before the court. Indeed, many of the documents that are here are actually documents that Mrs. Webb found lying around the house. So the disclosure is even less fulsome than it might appear from Mr. Webb. Any difficulties this causes should not be foisted upon Mrs. Webb, but Mr. Webb, because what we actually think the inference that was taken here, the complaint about values only has any purchase if the vesting of the lease would see Mrs. Webb get more than 50% of the property pool. Mr. Webb has not given evidence on the value of the property he is keeping, certainly not full disclosed evidence. Given that he could have disclosed documents from which value could be ascertained, it is an acceptable inference, having regard to those cases, that the property he maintains is worth at least 50% of the pool. And it is submitted that in substance is what the Court of Appeal's decision does. It takes the inference that Mr. Webb will still maintain at least 50% of the pool.
The assumption she gets the property.
Yes, my Lord.
Yeah.
And we say that that is an open and proper inference available to the Court of Appeal and should not be disturbed. Having regard to that, would the board like me to go through and look at the values?
Well, it's not in any detail. We're talking really about the solar 3,000 valuation of $2 million. It was plucked out of the air. What else could the board do?
Yes, well, our submission...
You said all these orders for discovery were sought and made and didn't produce anything. One's tempted to think that procedures for getting to the bottom of a spouse's resources are rather toothless in the Cook Islands. But then, of course, I suppose part of the difficulty is that if his sphere of operation was really New Zealand by this time, it was the documents were overseas, and so I suppose one shouldn't rush to a conclusion that the procedures are hopelessly toothless.
I would not rush there, my Lord. I mean, there is the power under Section 38(1) of the Act to appoint an independent person to assess value, and we did note to the High Court that that option was open to it. The difficulty, as we also noted to the High Court, was those procedures are only as good as the person whom one is investigating. And a glancing look at the difficulties even the Inland Revenue Department of New Zealand, with all its resources, have had in trying to unpick and find documents with regard to this individual, I don't fancy the chances of a court-appointed assessor.
It is rather extraordinary that we've got to this point after so many years of matrimonial finance litigation, and there is no evidence about the size of his income or the source of his income. But there it is.
Yes, my Lord.
Yes, so there was a void, and you say that it was permissible in respect of solar 3,000 for it to be filled in the way that the Court of Appeal did.
Yes, my Lord. Well, we actually say that the Court of Appeal could have filled it with 3.3 million, being the value that you could extract from that signed prospectus statement. Now, just to note, the only page we have of the actual final document is that last signed page, which would put a $10 million value on the company. Now, I accept that is thin, and there are difficulties with it, but what is one to do?
It doesn't matter, provided it's greater than 50% of the pool.
Yes, my Lord, and that is why I say that's what the actual substantive inference the Court of Appeal took on all those matters was, that we are satisfied that at the end of the day, if Mrs. Webb is vested the lease, Mr. Webb will still not be being shortchanged by what he is keeping from this pool.
So the value of the lease was 2.61 million? 2.83. So, he has to get in some form of assets, 2.83.
Yes, my lady.
Is there much more to be said on this point, Mr. Hikaka?
Unless the court wishes to go through documents, I don't know that would be useful, then no, there is nothing more to be said.
I've just got one question, if I may. Mrs. Justice Potter referred to a textbook, Fisher on Matrimonial Property.
Yes, my Lord.
We don't have that in the bundle, do we?
No, my Lord. Fisher on Matrimonial Property is one of the standard textbooks on matrimonial property law in New Zealand, it's now substantively changed, but the early editions, which is what Her Honour was referring to, related to the Matrimonial Property Act 1976, as it was then. I note that the Fisher of Fisher and Matrimonial Property is the same Justice of Appeal Fisher who heard this matter.
For my part, I think it would be quite helpful to have the relevant part of that book. I don't know how accessible it is in this older
If we
edition.
can get it online. Looks like it.
So that will be probably the new
Lexis.
version. Will be yes, it is a Lexis publication. So
What edition do we want?
first or second? I can't remember whether Her Honour used first or second.
Can it be left on the basis that either the library has it here or will get it from another law library in London? And if not, we ask a council to provide a copy. Would that be acceptable to you?
Yes, indeed.
I don't know whether you overheard that, Mr. Hikaka. For the time being, we're going to see whether we can get it as a result of our own efforts. But it may be that after this hearing, we will be contacting you and Mr. McIntyre, asking for
It's early edition.
copies of the relevant edition, the relevant part of the relevant edition.
Certainly, my Lord. Thank you.
Thank you. Now, is there anything else to be said, Mr. Hikaka?
No, unless there is anything further I can assist the board with, those are my submissions.
I don't think that there is. Thank you very much indeed. Now, Mr. Mullins, are you going to follow? Oh, Mr. Mullins, your big moment. Oh, well, Mr. Mullins, you've come a long way. Give us 5 minutes on perpetuities.
Cook Islands have the rule against perpetuities as it existed in common law because as it existed in common law, the Cook Islands have that version of the rule against perpetuities because there has been no amending act or reforming act such as the 1964 acts which were passed throughout the Commonwealth or the more recent acts such as in England and Wales. So it's been recognised that that's the position in a case which we have in the bundle at 1747 paper numbering 1758 electronic. It's only two.
What is the case?
It's a case called Pokoate, which is a...
Which volume?
that will be the Secondary Authorities' third volume.
And the electronic page number again, please?
1758, I think, is what it should be, my lord.
Indeed.
And I only cite that to confirm the position that there is no departure from the original common law rule. No wait and see, Your Honour. So my lord, and a modern statement of the ancient rule is actually found in this board's decision in the Air Jamaica and Charlton case, which is not in the bundle, but I expect that my lords and my lady will be more familiar with it than I was until I had to look it up and read a lot about it because we haven't had it in New Zealand for a while. Which is that no interest is valid unless it must vest, if at all, within a period of life and being at the time of the settlement, plus 21 years, plus maybe a period of gestation. So the problem with the rule, of course, is that it has to be applied at the time of the settlement, and much to the disappointment of many people who create settlements, it is applied remorselessly, as Lord Millett said in that Air Jamaica case. So if there is any possibility, however remote, that it may vest outside the perpetuity period, then it is defeated. Now, for an interest to vest, the person in whom the interest has to vest has to be ascertained. It must be ready to be vested in possession as well as interest, and there must also be an identification of the size of the interest to vest. And I take that from a comment in Lewin, which is also in the bundle at, we don't need to go to it, my lords and my lady, at
Give us the reference.
1885, original numbering 1896 electronic. And here we come to the mistake that we made in the respondent's case about the periods for each of the trusts. because the Webb family trust actually has a trust period of 60 years, which
Where's the mistake?
the mistake in our written case, my lord, is at paragraph 110, which is 9988 electronic 977.
What was the mistake?
The mistake is to think that there is no problem with the Webb family trust's express trust period. So the Aotearangi Trust has a trust period of 21 years with no selection of the life and being or lives and being against which it must be measured. So that period is unobjectionable. But the 60-year period is objectionable because there is a possibility, however remote, that all of the lives and beings shall die the day after the settlement, having appointed a new person. It's a 60-year period, my lord, which means that it's void at common law. Quite, my lord, but it behooved me to point that out because it was an error in the submission because it simply fails.
Okay.
So, moving on to the non-mistaken part of the submission, the original offence or the issue taken is that there is a precondition for both trusts to vest, which is that there is an appointment by the trustees amongst the objects, and my learned friend has pointed to a case where it had been implied, albeit around the time that reform of the rule against perpetuities was being enacted, although there were obviously settlements which predate 1964, so were all treated under the old rule. But in effect that a trustee can be expected to exercise a discretion necessary in order for the interest to vest in time. So the authority referred to there said that when we're interpreting a letter that says a person must decide amongst some objects who shall receive the proceeds of an insurance policy, we can imply into that, or not quite the remorseless construction that might have been expected normally, an obligation to do so within the perpetuity period, which would be 21 years in the absence of selecting one. And in this case, we struggled for a while to find the authority that actually disposed of this question about the possibility that the trustee didn't make a appointment, i.e. the 21-year period or the 60-year period in Aotearangi, in Webb, apologies, my lords and my lady, had come up, but there hadn't been an appointment made, which would mean that it didn't vest, or there was a possibility that it didn't vest at all, and in fact the next day, because the trusts terminate, it would result, meaning that it vested outside the perpetuity period. The further research is done turned up a case called In re Atkins Will Trusts, which is, I will give your lordships and your ladyship, the citation is 1974 1 Weekly Law Reports 761.
This is a pre-1965.
This treats the trust pre-1960, yes, 1965, my lord. And that case, which I located the other day, says that in terms of the possibilities, the possibility that it vests outside the perpetuity period arising from a breach of trust shall be disregarded, which means that the question in relation to the argument on these two trusts becomes very fine, because if the only way that it can vest outside the perpetuity period because the trustees must make an appointment is by dint of a breach of trust, because the trustees are obliged to make an appointment, that possibility is to be disregarded, and that would save the Webb family trust, your lordships, your ladyship, it would save the Aotearangi trust, because the power is only exercisable within 21 years, and if there is an obligation to on the trustees, meaning that the only way that it would vest outside of time is because they breach trust, then that Inri Atkins Will Trust's case would mean that that possibility isn't within the realm that we consider for the purposes of the rule. However, I return, and I'm not sure how I'm doing with my 5 minutes, to the fact that both trusts are ambulatory in the sense that at any time there is a possibility of a nomination with immediate effect, meaning that the trustee doesn't actually know who the final beneficiaries are until a theoretical time on the last day of vesting, because a nomination is not limited in time, it could be given on the last day. So the submission, my lords and my lady, is that even the most conscientious trustee seeking to make an appointment effective in vesting in interest in terms of the shares on the last day could not ever be assured from a mathematical perspective that there would be a valid appointment vesting on the last day, because we don't know who the final beneficiaries are going to be. And when one looks at the other trusts that have these kinds of structures where the trustees have a discretion as to whom the interest in the trust property will vest on the vesting day, normally there is something of a different waterfall, which is as the trustees may by deed appoint, and failing that, as it would have been on the intestacy or something like that, various formulations, which means that it is certain that we will know who it is that takes an interest and how much that interest is, which are the requirements for vesting. So it's actually, in a way, an argument, my lords and my lady, which reinforces the effect of clause 10.1 on both of those trusts in making them really much more of a settlement in the nature of Mr. Webb being able to direct where property might go for a period of time, because in my submissions, my lord, my lady and my lords, both trusts do not sufficiently identify to whom and in what shares they may finally vest, which means that there is a perpetuity problem with them, as well as all of the things that my learned friend Mr. Hikaka has pointed out. I do thank my Lord Wilson for the indulgence of saying something about it.
Your submissions may prove not to be decisive. They may prove to be only remotely relevant. But they were interesting. And speaking entirely for myself, they were educative. Thank you, Mr. Mullins. Mr. McAnally.
Thank you, my Lord. And thank you to my learned friends for the brevity. I'm on my feet again sooner than I had expected, and I won't trouble your lordships and my lady long. I have an outstanding question from my Lord Briggs from yesterday, which I'll deal with briefly. And beyond that, I don't intend on saying anything more about the trust questions. Those have been well traversed, and the written cases deal with matters that haven't been. But I do have a couple of points I'd like to make in relation to the debt matter. So I'll start with my Lord Briggs' question from yesterday, and the question, as I recall it, was whether or not a personal power might be vested under the matrimonial property regime in appropriate cases, to which my answer in principle is yes, assuming that the power is truly personal in that sense, and the relevant sections to assist. Sections 25.3 and 33.3c of the Matrimonial Property Act. I, of course, submit in this case that the power isn't personal. I do say it doesn't exist in respect of the Webb Family Trust. I did note my Lord Briggs's comment regarding the potential for collusion, I suppose, between Mr. Webb and Mr. Allison, and I guess that is a matter that we can always speculate upon. But I would say, even if that is a rational exercise to embark upon, it does mean that at best there might be a beneficial interest of some sort in the power that it does in fact legally belong to Mr. Allison, and that raises difficult questions of its own in terms of how that might be treated in terms of value, and or how it might be treated as a vesting exercise.
Which of the two sections you mentioned, 25?
Section 25.3, my Lord, and Section 33.3c. The final point I'd make before leaving that, what I'd call a trust question, is that the existence of the power in relation to the Ararangi Trust presupposes the validity of that trust, and therefore it raises vesting would probably be of no practical utility, because then we run against the problem that, assuming the Webb family trust is valid, that there are assets within that which are outside the matrimonial pool, and vesting the personal power, if there were one, in Mrs. Webb, would have the likely effect of giving her more than half of the matrimonial property pool, which of course Mr. Webb submits is the case as we presently find ourselves. Now, my Lord, that was all I was going to say on to try and answer my Lord Briggs's question and on the trust questions. I was going to move on to the debt now, if that's convenient.
It is convenient.
So the starting point I wish to take is my learned friend Mr. Hikaka's reference to Section 21A of the Matrimonial Property Act, and his point, of course, is that the rights of a creditor aren't affected if the creditor has no rights, because a debt is unenforceable against particular assets. One of my lords, and I apologise, I can't remember which of my lords, did put it to my learned friend that does require something of a gloss to be placed upon Section 21A, and of course I do submit that as the case. 21A in my submission simply sets out what the purpose of Section 20 is, and it is the operative parts that follow which specify how the purpose is to be given effect to, and that purpose is of course creditor protection. And there is a passage from the leading Court of Appeal decision, which the Court of Appeal in this case did refer to, and Wilson, that I'd like to read to my lords and my lady, if the board does wish to refer to it. It is at page numbers 1868 and 1869 of the bundle, and that will be sitting at 1879 electronically. And
we will look briefly at it. Which volume is it in?
Volume 3 of the secondary bundle, my lord. At this point, there is an 11-page difference between the physical and the electronic. I'm sorry, my lords and my lady, I cannot ascertain why that is the case.
Don't worry.
I've tried, but it is beyond me.
AP, isn't it? Yes.
And it's the passage I'm interested in starts at page 694 of the report at the very bottom. The court observes that Section 25B provides a sensible and straightforward way for the protection of creditors in arriving at the value of the matrimonial property owned by that spouse. It says, any separate property of a spouse is available to meet the unsecured personal debts of that spouse, and that's self-evident, we know that.
I'm not with you.
Nor am I.
Page 694.
The very bottom,
The
my
paragraph,
lord.
it follows from this.
It follows, yes.
Yeah.
It's that paragraph. And what I'm most interested in is that part that says, if and to the extent that there is a shortfall, those debts are deductible against matrimonial property owned by that spouse, so that it too is available for the creditors. I submit that the use of the phrase "for the creditors" rather than "to the creditors" is significant, and it informs the proper interpretation of Section 21A, which I had better take the board to, if I may, and that is at page 1014 of the primary bundle of authorities behind tab D, and I can only speculate that that will be at page 1022 of the electronic version, assuming an 8-page difference at that point. Section 21A is...
What are we looking for?
Section 21A of the Matrimonial Property Act.
Oh, that's at 1025.
So we are 11 pages at this point as well. Right. And it says, secured and unsecured creditors of a spouse shall have the same rights against that spouse and against property owned by the spouse as if this Act had not been passed. Bearing in mind the approach that the Court of Appeal took in Wilson & Wilson that I've just referred the board to, and that I commend to it, the reference to rights against the spouse and against property owned by the spouse is consonant with the fact that the section deals with both secured and unsecured creditors. So when it refers to rights against property, it is referring to the rights of secured creditors who do have what I might call in rem rights against property, but it also refers to the position of unsecured creditors whose rights are personal and against the spouse personally. And so there is no magic in my submission that requires the balance of Section 20 to be interpreted in a way which requires us to embark upon this rather difficult exercise of trying to figure out what a creditor may or may not enforce against. The important point is, in the case of an unsecured debt, is that the creditor is able to obtain a judgment against the debtor personally, and what follows from that will just depend upon execution processes. And the rights of the creditor against the spouse personally is an expansive term, and I followed with some interest the argument not so long ago regarding the bankruptcy regime in New Zealand and the Cook Islands, and I'm not sure I followed the argument fully, being still somewhat dazed and confused from travel, but Section 655 of the Cook Islands Act 1915, of course, says...
Section 655.
Let me just check that, my lord, to make sure I am correct on that. Section 655 yes. of the Cook Islands Act 1915, which I took from the argument to be what was being referred to. Now, that section has not been repealed in New Zealand. I don't understand it to have been repealed in the Cook Islands, but I am not sure about that, my lords, my lady. So please take what follows with that in mind, and to explain, in case the board is unfamiliar with it. Of course, on Constitution Day in 1965, the Cook Islands adopted New Zealand legislation for the Cook Islands that had been enacted by that point. But from that point on, the Cook Islands was at liberty and did amend that New Zealand legislation for its own purposes. So what one finds is that whilst the Cook Islands Act 1915 of the New Zealand Parliament remains in force in the Cook Islands, there are a number of amendments to that legislation over the years passed by the Cook Islands Parliament. So with that caveat in mind, and I do not understand section 655 to have been repealed, but subject to that,
You understand it has been repealed?
I don't believe it has been, my Lord.
No.
I thought we were told that it hadn't been repealed.
No, no.
Yes.
We
misheard you.
I believe that is the case, but what I wish to do, my lords, my lady, is to be clear, to be sure that I'm not misleading the board, and I am not sure if it has been repealed or not.
We understand that.
I do not believe it has been. But what that section, I should say, provides for is that in the event of bankruptcy in New Zealand, the official assignee shall have the same rights in respect of property owned by the bankrupt, obviously, situated in the Cook Islands as if it is located in New Zealand. Now, I'm certainly not saying that is some sort of lay-down misere from Mr. Webb's point of view on this particular point, nor do I rely upon my answer to my Lord Carnwath's question yesterday about what the revenue in New Zealand is doing about the debt, because it's not relevant, and
I mean, what are your instructions? Or do you
those are
not
my
have any
instructions, my Lord. Those are my instructions.
What?
That proceedings have been commenced for the appointment of receivers in respect of all of Mr. Webb's property, and those proceedings refer to both New Zealand and Cook Islands based property.
But I mean, do those instructions come from a lawyer? Someone actually?
No.
No. Well, then,
No, they come
what
from
weight
Mr.
would
Webb.
you put on it?
I would submit none, my Lord,
Good.
because you don't need to.
Right.
And the reason you don't need to is this, and because if I am wrong and the Government of India rule applies, then irrespective of what a receiver may or may not be appointed in respect of, there may still be issue that receiver, as an agent of the revenue, may well still have to bring enforcement proceedings in the Cook Islands anyway. So a whole new set of proceedings arises, and the matter is no further ahead as far as what we're trying to resolve. But the significance, I say, of section 655 is twofold. If I am right, and it hasn't been repealed by the Cook Islands Parliament, whilst a number of sections around it have been, or appear to have been, the Cook Islands Parliament has continued to permit execution in the Cook Islands against property in respect of debts owed by a debtor located in New Zealand. And that, in my submission, is consistent with the degree of cooperation as far as mutual recognition of each other's interests, I suppose, as far as that goes. And I'll come back to that because I haven't put it very well at all. But it would be anomalous in my submission if the Cook Islands continues to permit that as part of its special relationship with New Zealand, but then expects the official assignee to be able to enforce on behalf of creditors some debts but not others.
Do you rely on this provision yourself, 655?
I rely on it only...
Are you adopting it as part of your submission, that this is effectively an answer to the appellant's case?
I'm relying upon it so far as it is part of the context in terms of what I'm ultimately submitting, my lords, my lady, is that what we are dealing with is a relationship that is governed by legislation. It has developed incrementally over time. And I was going to refer back to the exchanges of correspondence between the Prime Ministers and Premier of the Cook Islands, as the case might be, which in fact emphasises the nature of the special relationship. In fact, but for the special relationship, that correspondence would be unnecessary. The relationship would be governed by some form of treaty as a matter of international law. It's not. It's governed by the constitutional and legislative arrangements that are in place between the two countries. But what that correspondence, I should say, emphasises is a partnership. It's not a partnership in a commercial sense, I suppose, but it's a partnership that does have a name, and the name of that partnership is the Realm of New Zealand, of which the two partners form constituent parts. And that partnership contemplates the maximum cooperation. It is identified by shared sovereignty. It is identified by shared bonds of citizenship, the upholding of mutually recognised values and standards. And as part of that partnership, we have the memorial process that we traversed yesterday, which makes the enforcement or the registration and enforcement of judgments in one country and the other very straightforward and far more straightforward than any other reciprocal enforcement regime. And we have legislation which includes provisions such as Section 655, which comes down to this in my submission, is that the relationship is ultimately legislative. And it is a unique one, and it is special, and it is not a relationship to the Government of India rule has ever been applied. It was applied in, the rule was applied in that case, of course, because it always had been. It was applied between India and the United Kingdom, which by 1950 were, of course, quite separate, the days of empire having ended. Obiter, in that case, is, well, the fact that the two parties might be the parts of the Commonwealth doesn't matter, and that makes complete sense, because Commonwealth countries are independent in the sense the Queen of Australia is not the Queen of New Zealand, and so forth. But we're not talking about two Commonwealth countries here. We're talking about one, in the sense that they share that sovereignty in terms of the head of state. So what I am submitting, my lords and my lady, and what this comes down to, I suppose, is that the preconditions, whatever they might be for the application of the Government of India rule, have never existed. They didn't exist prior to 1965. They didn't exist prior to 1969 when the High Court of New Zealand still had civil jurisdiction in the Cook Islands, and there has been nothing happened since to make it apply. My lords, my lady, that was all I had noted, and if there's nothing else I can assist with, those are my submissions.
When I asked Mr. Hikaka a question, looking at it very broadly, about the fact that this is a debt in New Zealand referable to tax that should have been paid for a number of years, mainly when his client was living with and married to your client. And I made the suggestion that it was highly likely that she had been the beneficiary of, as we have seen, very large sums of income enjoyed during those years and no tax paid on them. One of his answers was, well, of course, it's agreed that this is a personal debt and not a debt. And it may not matter what label is put on it for the purposes of the question that I asked, assuming it had any validity at all. But as a matter of interest, why was it conceded that this was not a debt and was instead a personal debt, bearing in mind the provisions of the 1976 Act, in particular, Section 27D?
The short answer, my lord, is perhaps twofold. One is, and as perhaps has already occurred to the board, is Section 27 is relatively limited in the sense of what falls within that section as not being a personal debt.
Well, quite.
And so that was the first question. But what it ultimately came down to in this case is that the debt we're concerned with was, partly incurred during the course of the marriage, but partly not.
Yes.
And ultimately, my lord, it came down to too difficult in the time that was available to try and identify what was within and what was without.
I see.
But my lord's point, from a practical point of view, remains valid in the sense that there's a lot of concern, I suppose, around the fairness, I guess, of the result, whatever the result might be. But there is going to be unfairness one way or the other. That is unavoidable. It is either going to be unfair to Mrs. Webb because of the implications of the section, or it's going to be unfair to Mr. Webb because his ability to pay the IRD is going to be compromised. And that is going to be unfair to the IRD as much as anybody, because its negotiating position, its rights are limited, because the debt is going to have to be dealt with in some way. And it is certainly the case that the money to which the debt has attached was, to large measure, not entirely, earned, applied and used during the marriage. And a good example is the very acquisition of the Arangi property, which was acquired by one of these advances, which is now being deemed by the Inland Revenue to be income.
I think that final observation is very valid about unfairness, one way or the other. But this Act puts one in a straitjacket.
It does, my lord. It does. It is very clear. And to apply it in some other way, which requires the courts to embark upon some crystal ball gaze in terms of what a creditor may or may not be able to do, what a debtor may or may not do, is not what is contemplated by it in my submission.
Now, let me see whether my colleagues have
Can I
questions.
just check with you, the tax debt includes actually a relative to the total figure small amount of the tax debt, and a lot of it is the penalties and
That's right, my
so
lady.
on, isn't
The
it?
court
So
has-
it might also be said that the tax debt is potentially for the benefit of the family, but the second, the penalties and so on, might not be. So, I mean, there's complications about splitting this up, isn't there?
It is very, very, very complicated, my lady, and I suppose one could equally say that while to the extent tax wasn't being paid that should have been, then the unpaid portion of the tax was available for the family.
And the core debt's about 4 million, isn't it?
It's roughly 4 million, my lord, yes.
Very well. There are no further questions. It remains for me, on behalf of the board, to say that we all five of us have been really assisted by the advocacy. And let's not forget Mr. Marshall and Miss Clues. It's been a joy having you over here addressing us. And the board will now take time to consider what advice humbly to tender to Her Majesty.